Constitution of India, procedure for amendment, nature of amendment process. The nature of amending process envisaged by the makers of our constitution can be best explained by the referring the Pandit Nehru observation quoted under the reconciliation of a written constitution with the parliamentary sovereignty. That is, the constitution should be not be so rigid that it cannot be adapted to the changing needs of national development and strength. There was also a political significance in adopting a facile procedure for amendment, namely that any popular demand of or changing the political system should be capable of realization if it is assumed as considerable volume. In the words of Dr. Ambedkar explaining the proposal of amendment introduced by him, Constitution Assembly, those who are dissatisfied with the Constitution have only obtained two-thirds of majority, and if they cannot obtain even a two-third majority in the parliament elected adult franchise in their favor, the dissatisfaction with the Constitution cannot be deemed to be shared by the general public. The element of flexibility were therefore imported into the federal constitution, which is inherently rigid in its nature. According to the national traditional theory of federalism, neither the process of amendment of the constitution federal constitution, which is the inherent rigid nature. According to traditional theory of federalism, either the process of amendment of the constitution entrusted to a body other than the ordinary legislature, or a special procedure is prescribed by such amendment in order to ensure that the federal compact may not be disturbed at the will of the parties of federalism, the federal legislature. But as has been explained in the outset, the framers of our constitution were also inspired by the need for the sovereignty of the parliament elected by universal suffrage to enable it to achieve a dynamic national progress. They therefore prescribed an easier mode to changing the provision of the constitution which did not primarily affect the federal system. This was done in two ways: by providing that the alteration of certain provisions of the constitution were not to be deemed to be amendment of the constitution. The result is that such provision can be altered by union parliament in the ordinary process of legislation. That is, this is a simple majority. Other provision of the constitution can be changed only process of amendment, which is prescribed in the article 368 by the differentiation has been again made it the procedure of amendment according to the nature of provision sought to be amended. While all these amendment of the constitution, a bill has to be passed by the union government by special majority in case of certain provision which affect the federal structure. A further step should require a rectification by the legislature as list of at least half of the state therefore will be presented to the president of the assent article 368. But even in the latter group of cases, the law which eventually effect the amendment in the law made by parliament, which is the ordinary legislative organ of the union, there will thus be separate constituted body provided by the our constitution for the amending process. The procedure for the amendment. An amendment of the constitution may be initiated only by the introduction of bill for the purpose in either house of parliament, and when the bill is passed in each house of majority more than 50% of the total membership of that house, and by a majority of less than two-thirds of the members of the house present and voting, it shall be presented to the president for his assent. Upon such assents being given to bill, a constitution shall stand up amendment in accordance with terms of bill. If, however, such amendment seeks to make such changes, the following provision timely, or namely, the manner of election of president, article 54 and 55, extend the executive power of union and the state, article 73, 162, the Supreme Court and the High Courts, article 241, chapter 4th and 5, chapter 5, of Part 4th, Distribution of Legislative Power between the Union and the State, Chapter 1st and Part 9, any of the list in the 7th Schedule, Representation of the State in Parliament, Article 80 to 81, 4th Schedule, provision of Article 368 itself. The amendment shall also require to be ratified by the legislature of not less than one half of the state by the resolution to that effect passed by those legislators before the bill making provision of such amendment is presented to the President for the assent. Article 368(2). The constitutionality of the Constitution 97th Amendment Act 2011 was challenged by the Rajendran N. Shah Union of India, wherein the Gujarat High Court delivered its judgment dated 22 May 2013 WPPIL number 166 of 2012 and declared the Constitution 97th Amendment Act 2011, which inserted Part 9th B containing Article 243ZH to 243ZT as ultra vires of the Constitution of India for not taking recourses of Article 368(2) of the Constitution, the providing for the ratification by the majority of the state legislature. The Supreme Court, by the majority of 2-1, upheld the judgment of the High Court except the extent that the struck down the 9th B of the Constitution in its entirety. The Supreme Court held that since the Constitution 97th Amendment Act dealt with an entry which was an exclusive state subject, we require a ratification by the least one half of the state legislature as per Article 368(2) of the Constitution. General feature of amending procedure. It is clear that the amending process prescribed by our Constitution has certain distinctive feature as compared with the corresponding provision in the leading constitution of the world. The procedure of amendment must be classed as rigid insofar as the require a special majority and some cases a special procedure for amendment as compared with the procedure prescribed of ordinary legislation, but the procedure is not complicated or the difficult as in a USA or in any other rigid constitution. The subject to the special procedure laid down the Article 368 of our Constitution vests constitute power upon the ordinary legislature of Union, the Parliament of course acting by a special majority, and there no separate body for the amending the Constitution as exists in some other constitutional convention. The state legislature cannot initiate any bill or proposal for the amendment of the Constitution. The only made the initiating proposal of amendment is to introduce a bill in either house of the Union Parliament. Is subject to the provision of Article 368 Constitution Amendment Bill are to the passed by Parliament in the same way of ordinary bill. In other words, they may be initiated in either house or may be amendment like other bills, subject to a majority of required by Article 368, but the special majority prescribed they must be passed by both the houses like any other bill. No joint session for constitution amending bills. In would be pointed out the contrast there that there is another important point on which the passage of constitution amendment will offer from the procedure relating to a passage of a bill of ordinary legislation. Article 108 provides that if there is a disagreement between the two houses of parliament regarding to passage of a bill, the deadlock may be resolved by a joint session of the two houses, but it is clear from Article 108(1) that the procedure for the joint session of applicable only bills of ordinary legislation which come under the Chapter 2 of Part 5 of the Constitution and not to bill of amendment of the Constitution which are governed by the self-contained procedure contained in the Article 368(2). A requirement of a special majority in both houses in Article 368(2), which would have been negatory had the provision as the joint session has been available in the SAFER. The previous sanction, the President is not required for introducing the Parliament any bill for amendment of the Constitution. The requirement relating to ratification by the state legislature is more liberal than the corresponding provision in American Constitution, while the latter requires ratification by not less than the 3/4 of the state. Under our Constitution, ratification by not less than half of them suffice. In case an ordinary bill governed by Article 111, when the bill, after being passed by both houses by the Parliament, is presented to the President, he may, instead, by assenting to it, declare that the withhold assent. Therefore, in the latter case, the bill cannot become an act, but the amendment of Article 368 in 1971 has been obligatory for the President to give assent to a bill for amendment of the Constitution when the presented to him after the passage by the legislature.